As the rollout of the Planning and Development Act 2024 begins, today we explore from a legal perspective what it may have gotten right, as well as issues it may have stored up for the future.
I don't know if, as practitioners, and also even in the courts, whether it was the Planning Act per se that was giving rise to difficulties in terms of delivering on permission. Consolidation and clarification is really helpful, but I think that whilst the new Act is welcome in many respects, it's not necessarily where the issues are coming from.
I'm Sean O'Leary, and you're very welcome back to the Planners Podcast. On paper, the Planning and Development Act 2024 aims to streamline the planning process, improve legal clarity, and deliver better outcomes. But as many in the sector already know, the path from legislation to real-world impact is rarely straightforward. Today, we're digging into what the Act gets right and what it misses, along with looking at the challenges of implementation, with the pressures around judicial review, and whether the Act supports Ireland's climate and environmental goals. To guide us through it all, I'm joined by partner at Philip Lee and Chairperson of the Law Society's Environmental and Planning Law Committee, Rachel Minch. Rachel, you're very welcome to the show.
Thank you, Sean. I'm delighted to be here.
This is all part of trying to make something impenetrable, potentially impenetrable, slightly more comprehensible, accessible, and we'll see. And hopefully over the course of these, we'll look at loads of different stuff. But you were somebody that we were really eager to get on. And that's probably a good place to start, actually. If you could just kind of briefly explain your background and how you ended up specialising in planning and environmental law, and then maybe what you do in Philip Lee on a kind of day-to-day basis, and then the kind of committee roles and the different other roles that I know you're involved in too. I think would be really interesting to hear.
Great. I think my interest in the area actually started when I was very young. I attended middle school in Washington, D.C. in the 80s, and they were already teaching students about environmental issues at that point, including deforestation, habitat loss, issues that really, would grasp your imagination as a child, and I suppose the injustice as well of things that were happening. My mum was also a lawyer, and I suppose I put two and two together and decided I wanted to become an environmental lawyer from a young enough age. I then qualified in McCann Fitzgerald, where I was lucky to join the construction team and started working on environmental issues in the context of big road projects, waste development projects, and from there moved to Barry Doyle and Company, where I started working for the EPA and on board Finola. And I was there then for 10 years before I joined Philip Lee in early 2014. And obviously we're in the middle of a recession. They were very good to take me on. And it was just myself and Alice Whitaker at the time. And now we are a team of 8 people. Alice and I head up the Planning and Environmental Group. And I think what's really interesting in this area is to see kind of how it's evolving. So, from the kind of classic planning issues and planning advice and cases that we would have been working on initially to now working on peat restoration projects, nature restoration, climate finance, forestry, aquaculture. It's a really fascinating area. I feel very privileged to work in it, and I think what we really love in the team is that wide variety of the work, but also the wide variety of clients who trust us to do that work. In terms of the Law Society Environmental and Planning Law Committee that I chair, obviously the Law Society saw a real need for a specialist committee in the area, so we were set up in late 2022, and both myself and the Law Society were very keen to draw together committee members that reflected a wide range of perspectives and represented a wide variety of clients so that we could really, I suppose, put our heads together and see if we can identify common ground in I suppose, what is a controversial area. So I hope we have achieved that. In terms of what we do, a lot of it is educational. We arrange conferences. We had the first Climate Justice Conference for the Law Society. We've obviously had conferences on the Planning Act. We also engage with other committees, so the Climate Bar Association and the Planning and Environmental Bar Association for barristers. We make submissions during the course of the legislative process, including my first appearance before a joint Oireachtas committee, which was really interesting. And more recently, we've been making a submission on the Aarhus National Implementation Plan. So that's it. Conferences, submissions, working on legislative change, and seeking to engage with the wider community and other professional associations.
In terms of, I suppose, your impressions of the Planning Act then, does the final piece of legislation address the concerns that practitioners would have raised in Oireachtas committees through the legislative process? Is there anything in it that you think is particularly welcome, or is there anything in it that you really do wish had been addressed during that Oireachtas period? I suppose just some initial high-level impressions of.
I don't think that, and I stand to be corrected, but I don't believe a lot of the concerns that were raised have actually been addressed in the 2024 Act. One of the main concerns across the board for practitioners, regardless of whether you're acting for applicant, decision maker, developer, was the concern that the new judicial review provisions, and in particular those relating to standing and costs, were going to generate further what's referred to as satellite litigation, and that they would then in turn hold up, I suppose, the challenges to the underlying development consents, which we've seen already with the cost provisions in Section 50B. So I don't think that has been heard so far. The Law Society has made a submission recently to suggest that those provisions be brought in at a later stage, and also after having been tested against the Aarhus Convention, that would be a proper compliance report in relation to those conditions. So in other words, let's let the new provisions of the Act bed down and not introduce new procedures by which their application is tested, as well as seeking to figure out what those provisions actually mean. In terms of what's welcome, I think there are many aspects of the Act which are welcome. One of them is the streamlining of the development consent processes. So I'm sure, as you know, Sean, we now have simply two types of application process: the standard application process, and then one application process where things need to go to the board, whereas at the moment we have different application processes for those for strategic infrastructure, local authority development, electricity infrastructure. So I think that streamlining is really welcome. Similarly, that there are now the same provisions apply to amend or extend all consents, though I think there are significant concerns about those provisions, which I might come to. Similarly, there's also a consolidation into a single section of the matters to which decision makers have to have regard, though that's not exhaustive, and also the types of conditions that can be applied. I think the changes to the system of making land use plans is also very welcome, and I'm sure the IPI has expressed very positive views in relation to those changes as well. So the longer lasting development plans, for example, the use of national planning statements to, I suppose, ensure consistency across the application of national policy, with the idea that stronger plan-led system will then hopefully reduce the number of judicial reviews of decisions that are made under them. I suppose a concern there is that we're going to need the resources to make those plans, and a lot of those plans now are also being challenged with increasingly stringent requirements in terms of their environmental assessment of plans themselves, and we'll see that reflected in recent decisions. Even, for example, an applicant, Protect East Meath and Meath County Council, brought the council to court over the failure to make a local area plan, and the council fully conceded in the case that they simply didn't have the resources to make them, and that they had been advertising for positions with a commensurate salary and people simply weren't applying for those. And the court judgment was very interesting in terms of recognising that and refusing to make a direction that the council make the plan in those circumstances. So, and perhaps I'm going on a bit of a tangent here, but the critical piece will be that we need the resources to implement the new plan provisions of the Act.
And there's two maybe interesting things there that I'd like to talk to you about. I suppose the first is how much of your role now, or have you seen a change, or maybe it's just kind of an anecdotal one, where the plan itself is being challenged, or it's the duration of plans, or the actual status of plans is the thing that is now being raised. It would appear that it's something that's become a much greater issue. And I suppose it's figuring out then, as we transition to the new arrangements, how that all works, and local authorities who may be starting a development plan or who have just adopted a development plan expected to change it. Are you seeing more of your work to do with the status or uncertainty about the actual, fundamental development plan, not even policies in it, but what development plan is the development plan, and is it still live and that sort of stuff?
Absolutely. I think in addition just to the development plans, you're seeing more challenges as to whether plans require a strategic environmental assessment at all, whether they need an appropriate assessment. We now have, and whilst it's not about a development plan, we're seeing a very significant reference in the context of the Nitrates Action Plan as to what the SEA directive requires, and indeed what the Water Framework Directive requires in relation to plans, which will also be applicable to development plans and other types of plans that are going to be made under the Act. So, for example, the extent of the assessment of alternatives. When you're doing an SCA, the extent to which impact on material assets can be taken into account and the weight to be given to them. But also, I think significantly, whether the Water Framework Directive requires a separate standalone form of assessment as to whether the plan is going to cause a deterioration in the status of water bodies or jeopardizes the attainment of good status. So I think what we're seeing is, as you say, an increased focus on plans, what the environmental assessment process requires in relation to those plans, with possibly increasingly rigorous standards being applied to those. But also, as you say, issues around whether development consents can be granted when plans which ought to have been in place are not in place, or also if the plan hasn't been lawfully adopted, what is the status of development consents which have been granted under them? And there is a European case lurking around in the background about that particular issue. So I suppose maybe a level of caution and concern possibly around that. Though we did have a judgment last week where the court, notwithstanding that a local area plan ought to have been in place in relation to the area in which the development consent had been granted, said, look, I can't just quash the decision solely because of that, because actually that would mean then, no development consents could be granted until the plan was put in place. So some pragmatism, but also, I suppose, words of caution in relation to the extent of assessment that may be needed for all of these plans.
And actually, and I know we'll come back to it, but in terms of that pragmatism type thing, it might be useful just to talk a little bit about some judgments. I mean, obviously, Cool Glass recently got a lot of attention, but do you have anything that you'd like to, I suppose, emphasise about that you think people have maybe missed? Or are there other judgments or trends in judgments from the Planning and Environmental Court that you think are flying under the radar that are actually possibly much more significant than Cool Glass, which did get the headlines, I guess?
I think Cool Glass is one of the things I wanted to comment on in relation to that was, I think that judgment is a very interesting sort of headline and significant judgment, which it recognises the dire consequences of climate change if we fail to address them and fail to address it in the context of the development plan process. But what I think it also reflects is a vacuum in our existing legislation as to how applicants and decision makers are to go about integrating those concerns in the decision-making process. And I think in the future we'd like to see more guidance and possibly an updating of the Planning Act to address climate change considerations and how decision makers are to go about that. In terms of other judgments, I actually think what's interesting is this sort of recognition now of the need for proportionality when the courts are making their decisions. So, for example, we are now seeing a development in the concept of what is known as a harmless error. So, for example, if an applicant brings a case and alleges an legal error in the decision-making process, the court might recognise that and say, okay, an error was made, but is it a harmless error? So, in other words, is it an error that would have made no difference to the outcome of the decision-making process? And if that's the case, the courts are now saying we're not going to quash that decision. I think that's a very welcome development in the context of proportionality, that simply the fact that an error has been established does not mean the decision has to fall. There might be other ways in which the court might address that by way of declaration, but they're not going to quash the decision. And that was reflected last week. Now, this is a significant, actually, series of cases in relation to the Habitats Directive and whether, in order for a competent authority to carry out an appropriate assessment, there needs to be site-specific conservation objectives in place for the site. And if there aren't such measures in place, is it the case that the decision maker simply can't grant permission for the development? So that's been referred to the European Court of Justice in a case of Power and Bord Planola. But the High Court last week has also decided to refer this question in the context of AA screening. So in other words, do site-specific conservation objectives also need to be in place in order for the competent authority to be enabled to do an AA screening? And I think what's very interesting in the context of that particular case is that whilst the High Court has decided to refer that question, they've also decided that at this point they can rule out quashing the decision, because regardless of whether or not there need to be site-specific conservation objectives in place to carry out an AA screening, that wouldn't have made any difference here because it was so the site could readily be screened out, if that makes sense, Sean. So I think we're seeing a new, because actually I think the court also recognised if I say yes, if it's the case that site-specific conservation measures need to be in place, that's going to potentially put us a halt to any decisions being able to be made until the European Court comes back with an answer to that question. So I think we're seeing an interesting evolution in the case law in terms of that the question of proportionality and whether the error in issue or or the point that's being raised necessarily requires a quashing of the decision.
And I think it's a good time now maybe just to talk about JR in general and in the context of the Act. Obviously, JR was one of the most highlighted issues when it was going through the Oireachtas. And then I suppose judicial review itself is, you'd have commentators saying that this is the most significant issue in the planning system that's responsible for an awful lot of delays and uncertainty. And then similarly, you'd have other commentators as well, I guess, saying that in absolute numbers it's quite small, though obviously it's potentially big in terms of the precedent or the numbers or whatever like that. From where you sit, kind of in terms of the challenges that the planning system faces or the issues that we have in getting sustainable development or delivering infrastructure, housing and whatever else, how big an issue do you think judicial review is or maybe has been? Or would you have slightly more sympathy towards people who think that, look, it's significant, but maybe it's overblown? Or do you think actually that maybe it's, unless the legislation fixes this issue, it's not going to be able to achieve everything else that it wants to achieve?
So I think, yes, to some extent, I think it's overstated. But on the other hand, there's no doubt we've seen a huge increase in the number of judicial reviews. So when I started practicing, you might have had 30 or 40 a year, sometimes even 20, whereas now, you're hitting 100 to 150. This is just the board now, and not to mention, obviously, judicial reviews of decisions of other in other areas as well. So, I mean, I think it's no doubt that the significant increase in the number of judicial reviews. Of course, people will also submit that they only represent a small proportion of decisions that are made. But I think, whilst that might be correct, the fact of the bringing of judicial review proceedings and also the consequent judgments does have wider implications beyond those individual cases that are the subject of judicial review. So, for example, I think you can see there's an increasing cost in the preparation of applications, the extent of the reports that are also being submitted. Like, I was working on a relatively small application for planning permission, and I was just really obviously impressed, but quite surprised by the level of reports that are now needing to be prepared for what might be viewed to be seen quite minor applications. I think you're also seeing maybe the application of complex procedures to development, which again would not be seen as being inherently polluting or damaging to the environment. So the application of EIA and AA processes to development that arguably was never intended to be captured by the directives. You can also see decision makers understandably becoming increasingly cautious, leading possibly to longer decision-making times, reports, and arguably a very precautionary approach, again, to, for example, whether EIA, AA is needed, and then processes needing to go through that or needing planning permission as a result of that precautionary approach. And perhaps that could be the Sandymount cycle trial case is an interesting one, though ultimately the Court of Appeal decided that it wasn't an EIA class of project and didn't require AA, so it didn't need planning permission. But the High Court had concluded that it considered it needed to go through the planning process. Similarly, even the Bus Connects projects, for example, obviously they are also subject to judicial review, but there was a commenter, professor in Trinity, noting that, these developments effectively just required a change of lane from a car used by a car to a bus. I appreciate, of course, concerns around, taking people's lands along the route, but that these types of projects required vast and lengthy reports and going through EIA and AA, etc., in order to put in place some bus lanes. So I think there's wider implications, I suppose, of the JRs that are being brought and the judgments of the courts, including the European Court, that I think stretch beyond just the individual cases. That said, of course, judicial review has a very important role. It can bring clarity to what is needed. There are judgments that there are obviously situations where decisions need to be quashed or they need to be tested. So it's not to devalue the role of judicial review in a robust planning system, but perhaps the consequences of those judgments can have a wider reach beyond the applications themselves.
We've spoken a bit about Europe. I suppose one other thing that you do here is that one of the issues that we have in Ireland is shoddy transposition, maybe, or rushed transposition or things like that. Is that something that you think is that maybe an unfair way to, is that kind of abdicating responsibility for this, or do you think that actually has been the root of some of the challenges that you're seeing? And have you maybe seen any changes in how we're actually transposing legislation from Europe?
So interestingly, I'm not sure if transposition is the issue as such. I mean, I think sometimes we can fall down because the legislation just isn't clear enough. And perhaps, to be fair, Sean, yes, that can be as a result of rushed transposition. And I mean, the Greater Dublin Drainage project was a very good example of that, where the High Court dismissed all the grounds of challenge in relation to the environmental assessments, potential impacts, AA, all those grounds were dismissed, and the board's decision was quashed on the sole basis that it hadn't consulted with the EPA in the way in which the wastewater discharge regulations prescribed, and the board hadn't furnished its assessment to the EPA to enable the board to comment on that assessment. And I don't believe anyone interpreted the regulations in that particular way until the High Court shone a spotlight on it. And indeed, they were subsequently amended to clarify that that's not what was intended. But, through, I suppose, perhaps a rushed or unclear transposition or a situation, we now had the court then quashing it to go back to the board, but because of the passage of time, then they needed to go and seek further information for the developer to make sure it was up to date. Then that needed to go out to public consultation, come back, be assessed, and then go to the EPA. So, yes, small issues, can, and perhaps which looked like, that can be readily fixed. I just need to go back to the EPA now and consult. They can cause real problems if we haven't got clarity there.
Mm-hmm. And then there's small issues, but then back to bigger picture issues, I guess, and judicial review in the 2024 Act. And what way does the Law Society, I guess, see that working, or what way does your committee think it needs to work, or what would you like to see worked through before those provisions are commenced?
So we recently made a submission, again, focusing, I suppose, on the standing requirements and on the cost provisions. So in relation to standing, we've got a fairly established jurisprudence that, somebody needs to have a sufficient interest in order to have standing to bring a case, and there's established jurisprudence as to what that requires. What the Act seems to be seeking to try and do is to introduce this concept of issue-specific standing. So it's not just who has standing to bring the case, but what can you litigate? And so a party shall not be permitted to plead a ground in judicial review unless the party has a sufficient interest in the matter to which the ground relates. So we believe there's a material risk of complication around this, that we're then going to have litigation around whether each individual ground can be pleaded and whether the applicant has a sufficient interest in each ground that is pleaded. So we believe there needs to be clarity around that. We've also expressed concerns around the criteria that ENGOs and residents associations need to satisfy in order to establish sufficient interest. So it's not to say we appreciate that there need to be rules around which NGOs can bring cases, and we also appreciate why there would want to be some element of a certainty as to who the residents association is that's bringing the case. But when you look at some of the provisions, we believe there is a material risk that they will be found to be non-compliant with the requirements of the Aarhus Convention. So we are asking that, a specific, I suppose, Aarhus compliance assessment be carried out in relation to these standing provisions and also in relation to the cost provisions, though at the moment those are obviously very nascent and more regulations will be required, just to try and avoid, I suppose, issues down the road where we're going to potentially end up with references to the European Court as to whether they're compliant with EU law and Aarhus. So I think that is what we are suggesting, and we're also suggesting that these provisions be, I suppose, put on hold until that is done, and also until the provisions of the Act can be bedded down, so we're not bringing in this risk of satellite litigation in addition to litigation about the application of the new provisions of the Act.
I think the Aarhus point is a very interesting one, because it's something that we'd have heard a lot coming up over the course of the legislative process, I guess. The government seem very confident that it is Aarhus compliant, but I haven't been able to kind of I haven't had an opportunity to scratch the surface of that.
Yes.
Is that just kind of a vibes-based thing that it feels like it should be Aarhus compliant, but this issue keeps on coming up, and I'm just trying to understand why on something that should maybe be kind of more black and white than it seems to be.
I think that's also, we haven't found anything like a report or an official assessment, and to be honest, it would be a very interesting piece of work. So yes, so no, Sean, I think a vibe thing is maybe not a bad way to put it, and that's what we were asking. We think it would be that some sort of report or assessment should be prepared.
Do you think not by delaying introducing the JR provisions, do you think that's going to have any knock-on effects for anything else that the legislation is seeking to do as it's set out in the implementation plan and stuff like that? I mean, it seems quite distinct as a block of work, but do you think there could be arguments that, well, if we don't introduce this now, it's going to affect something else that we need to do?
Actually, that's a really good point because, and in fact, I would like to have gone back and edited our submission because I think there are certain very useful provisions in the new JR part of the Act. So our concerns are particularly around the standing and cost provisions. I think there are other aspects that are helpful and can be, brought in now, and those include, I suppose, the removal of certain steps in the judicial review process, which would serve to expedite matters and also reduce the administrative burden and costs on applicants. So, for example, the removal of the leave stage, the removal of a right of appeal to the Court of Appeal subject to an application to seek leave to appeal to that court. So you would be removing the leave stage and also the certificate application stage, so that once the High Court has made its decision on the substantive matter and any associated kind of cost decisions, applicants would just, or appellants would need to go straight to the Supreme Court. So I think, for example, those provisions can certainly be brought in now. There's certain tightening of the time limits in the new JR provisions, which I think could usefully be commenced now, including the criteria by which the grounds of challenge can be amended outside the 8-week period, and also just affirming that you need to justify a delay outside the 8-week period or beyond the 8-week period by reference to the same criteria. There's also a very important new provision, albeit not in Part 9, but which is related to a judicial review, which seeks to avoid the risk that a judicial review will be run down a significant proportion of the duration of a permission. So I think that would be a very welcome provision to bring in, which is where a developer now, where a judicial review is brought, can notify the local authority or MARA those JR proceedings have been brought, and then will notify them when the proceedings have finally been concluded. And then that period is not regarded, disregarded for the purposes of the duration of the permission. So I'm sure many people will be keen to see that brought in as well. And finally, there's also kind of a practical provisions which indeed reflect what the court is already doing, where if a judicial review is brought, the High Court can stay that judicial review to enable the public authority to correct the error where it otherwise has jurisdiction to do so, or indeed to enable the board to exercise some of its powers to correct that error. So I think there are certain provisions there which can very usefully be brought in now, which would seek to mitigate, I suppose, some of the concerns around the implications of judicial review for the implementation of critical infrastructure in particular.
While continuing to postpone the costs.
Exactly,
and some of the
that's it, and the standing, yes.
Yeah, and something else maybe just about timelines while we bring it up, and that was extending permissions. And we've seen commentary recently about looking for emergency legislation and things like that to blanket extend, I think, any ex-ante planning permission for a period of time. Is that something that, I guess, in your day-to-day work, is that something that you're seeing clients look to do? But then on the other side, is it something that raises questions for third parties, or how that actually is going to work in practice and how people do amend or extend planning permissions that are already in place?
Yes, that is definitely an issue that we are seeing in practice. And I can understand that the government has a difficult job in terms of trying to facilitate extensions and amendments of permissions, whilst at the same time ensuring that public participation in environmental assessment provisions are respected. Whatever about the emergency legislation, I think there is material concern around the way the 2024 Act is going about the changes, and so the way in which the Act is seeking to address alterations and extensions of permissions. So as we know, the new Act introduces like an enhanced procedure to alter planning permissions, but those same provisions with some changes are also now being made applicable to the extension of planning permissions. So whereas under the current legislation, there is a relatively short procedure with clear criteria as to whether or not you can get an extension of time applications now being treated almost like an application for planning permission. And if it's seen to be a material extension, then you're getting into public participation, further environmental assessments against the new plan, an inability to grant permission if the development would be a material contravention of the National Marine Planning Framework or the NPF or the development plan, and also the possibility of new conditions being imposed in an application to extend your permission. And I think the difficulty is that all of that, those requirements are being imposed or applied in circumstances where, in order to avail of the extension permission or provisions, you need to have commenced your development. So I think from that perspective, it's very difficult to see how developers would take the risk of having to commence their development, if you see what I mean, but then also being drawn into this very complex process with an uncertain outcome. So we believe, this isn't the Law Society, but I think those provisions would merit review before implementation.
And then one of the things that got a lot of attention, again, during the Oireachtas period was the changes to Section 5 and declarations and referrals. And, the Institute had concerns about it and maybe not quite understanding what it was trying to achieve. Is that a part of your workload at the moment, or have you thoughts about maybe the implications of that you think need to be thought through?
So it's not really coming up in terms of in our practice, but it's certainly something which practitioners did raise during the course of the legislative process as well. And it seems to me that, this provision is just still suffering a bit of an identity crisis as to what it's trying to achieve. So in seeking to, I suppose, to address the question, and it was a problem of multiple requests being submitted in relation to the same development, you're now, obviously, it's limited, subject to certain exemptions for NGOs and prescribed bodies. Now only the owner or occupier, person with their consent, can make the request. So that's fine, perhaps. But then to counterbalance the absence of public participation, or the fact that the public can no longer make that request, if a third party seeks to bring enforcement proceedings in relation to the development in issue, the declaration can't be admitted in evidence. So the developer doesn't have certainty if it's the case that enforcement proceedings can still be brought and their declaration as to whether or not something is development or exempt development can't be relied on in those proceedings. So it seems to me that the public can't avail of a relatively straightforward procedure to determine whether or not something needs planning permission, but similarly developers still don't have the certainty they need if that can't be relied on in enforcement proceedings. So I thought a good, approach to that might be that, only the developer, landowner or occupier could seek the request, but then a decision on the request for declaration would need to be made public, and then any person could appeal that to the board, and then that decision was final. You know what I mean? And could be relied on in the context of other judicial review proceedings or enforcement proceedings. So I think it's not quite found its happy place, the Section 5 process. And what's interesting about it as well, Sean, is that it's also been broadened. So you can include a request as to the meaning or scope of a permission or conditions attached. So I think in circumstances where the scope of it's been broadened, I think it's important that there should be some ability for the public to be involved in the process.
I don't want to turn this into a book review, but as a piece of writing, do you have views on, as a piece of legal writing, as a piece of legal text and as a piece of legislation that you are looking at, how easy is it to navigate? How well do you think it's achieved what it sought to achieve, which was to simplify, streamline? I think it was supposed to put everything all in the same place. Obviously, the 2000 legislation had turned into a behemoth, and it's been replaced by a behemoth, maybe in one volume sort of thing. As you've become more familiar with the final piece of legislation, just do you have any reflections like that? I mean, about how you actually think this is going to be to work with for legal practitioners, for planning practitioners, for communities, for everybody else, just as a piece of legal writing?
I think, to be fair, for both practitioners and also for members of the public, the fact that now you have, as we said, streamlined procedures for planning applications, streamlined procedures for streamline maybe isn't quite the word, the same procedure for alterations and extensions of consents, the fact that you have the environmental assessment provisions all in one place, I think all that should assist the public in accessing the legislation, and for practitioners as well to know where to look and to make sure that we're not caught up in terms of maybe slight differences in processes depending on the type of development you're looking at. And I think the plan section as well is particularly well written, and the application procedure is particularly well written. I found the alteration extension sections difficult. They're complex. I think perhaps they could be simplified. But overall, I mean, I know a huge amount of work has gone into it. A lot of lawyers were involved in preparing it as well. And I suppose we need to wait and see to some extent when we come to apply the detailed provisions in practice. But I think it's a well-written and clearly written piece of legislation, trying to address sometimes very complex legal points and requirements coming from EU law and otherwise.
I've got two last questions. I suppose the first is, you mentioned climate change and climate change and the Act. What do you expect the first piece of amending legislation we're likely to see is? And maybe is there something that you see coming that you think is going to amend it first, or maybe there's an amendment that you'd like to see? So obviously, again, one of the criticisms or one of the issues that arose around the 2000 legislation was just how often it was changed and how wide and deep those changes were, and actually try and keep track of it over the course of the 20 plus years became part of the difficulties of actually working with it. Do you see any amendments that you think are likely to have to come on stream relatively quickly, or are there amendments to it that you think could be brought forward relatively straightforwardly that would actually make it more workable?
I think the climate change hasn't been taken fully by the horns yet in relation to the Act. So I think we're going to need to look at amendments to give effect to the accelerated permitting regulations, to the requirements of the RED 3 directive in terms of timelines, in terms of potentially in relation to EROPI, and also I think we need to put some shape on the cool glass judgment as well, to facilitate applicants and decision makers in that respect. Obviously, I think, not to be forgotten as well, is that some significant things are also going to have to be done by the regulations, and in particular in relation to EIA screening. So I think there's going to be a lot of interest in terms of publication of those regulations, and also the exempted development regulations, and the implementation, I think, of a traffic light approach to AIA screening, which will be welcome. I think we're probably going to see, as with a lot of these things, devil is going to be in the detail. So not to obsess over site-specific conservation objectives, but another thing I looked at when I was reviewing the new Part 6 to govern environmental assessments, the AA screening needs to be carried out now by reference to the site's conservation objectives, which at present the High Court has found there is no textual requirement in the Habitats Directive for that to be done. So it's the little things that I think maybe as we get more familiar with it and start looking to apply these provisions that might then either catch us up or require further change.
And then one last question from me, I guess, which is there anything that you think is in the Act that is important that we haven't talked about, that you think the implications aren't fully recognised yet? Or is there anything significant that you think the Act is doing that you want to raise that we didn't cover?
So there's two things I'd like to say. I think that as a whole, the Planning Act itself, whilst I appreciate a lot of changes were made, the fact that it continued to be consolidated was particularly helpful. I don't know if as practitioners, and also even in the courts, whether it was the Planning Act per se that was giving rise to difficulties in terms of delivering on permission. The consolidation and clarification is really helpful, but I think that whilst the new Act is very welcome in many respects, it's not necessarily where the issues are coming from. I'd like for us to actually look at some of the wider consenting issues and difficulties that are arising for delivering on development consents. So, for example, and this is, I know is going perhaps slightly off topic, but derogation licenses. There's no derogation license procedures, I understand, for birds. The role of the MPWS is becoming increasingly important as, we have more stringent environmental assessment requirements. How can we kind of support them to get the resources they need to develop the guidance that's required to guide planning applications through the process, to enable them to make submissions on planning applications? We need more environmental data. So this is obviously perhaps more relevant to very significant development, but particularly in the marine, but with very limited data there to help inform the assessments and help to inform planning applications. So I would like to see more resources being put with the state-led, and perhaps that will also come through the nature restoration law, to enable more data and more to be available for people to then draw on to make their planning applications. I think also, obviously, there's a lot of focus on planning as a vehicle for the application of our many environmental laws, and of course it is that, but there's I feel perhaps an excessive focus on individual development consents and what they mean for the environment, rather than perhaps drawing and looking at the wider issues that are causing climate change, water pollution, biodiversity loss. Very often these are not individual development consents, but relate to wider issues in terms of land use. So I think that's one of the things, indeed, the Law Society is hoping to spend more time on is enforcement of our environmental laws more broadly.
I think there is an interesting point about the opportunity cost almost of this legislation, and the amount of time and effort and obviously political and technical input that went into it, and maybe how much of that could have been put into other guidelines or other laws or other licensing. And I think you're even seeing it resourcing. Maybe I could be wrong. I don't see a very different role for the MPWS or the EPA or anything like that. There's just an assumption that that'll work better than it worked previously, maybe without articulating that. And then even feels a million years ago now, but I mean, even things like discussions about a Department for Infrastructure during the last election campaign, and we're seeing things now about a strategic housing kind of coordination office and stuff like that, that there's some systemic things maybe that are much wider than planning and much larger than planning.
I think that's right. And even just, for example, maybe the number of consents that a single project, well, this is probably touching on that, needs to obtain, you know, so can we, for certain critical infrastructure, can we seek to simplify that again? Maybe, like there's one consent, which is your planning permission and your license and your maybe even CPO, or you might need planning from the planning authority or the boards, and some form of consent from EirGrid, then a consent from the CRU, then a consent from MARA, then, you know, and each step then potentially vulnerable to judicial review along the way as well. So yes, I agree that now that this piece of work has been done, perhaps we need to now turn to other areas.
Look, thanks so much for giving us your time and your expertise, Rachel. That was really, really interesting. And we covered an awful lot of ground, which I'm sure we're going to see take effect over the next couple of years.
No, thank you. I really enjoyed having this conversation with you, Sean, and I hope that we can continue it outside of this podcast.
Thanks, Rachel. If you would like to find out more about what we covered in this episode, you'll find notes, links, and more in the description area of this podcast. Do remember to press follow for our show so you'll get the next episode automatically, and remember to share it with a friend in the sector. Just tell them to search Irish Planning Institute on their podcast app. Our podcast today was produced by dustpod.io and brought to you by the Irish Planning Institute. From me, Sean O'Leary, thank you for listening.